Criminal procedure and the constitutional rights of U.S. citizens. So, what is a warrant? Well, essentially it's a court authorization for officers to conduct a search or make an arrest. As we know, that there are four components. One, must be based on probable cause. Two, must have an oath or affirmation, which is an affidavit with the application. Three, must be issued by a neutral magistrate, not by the police or the law enforcement side of the prosecution service. And must have particularity, individual place identified. Remember, the Fourth Amendment was drawn up as a reaction to the British general warrants that were considered overly broad. A warrant does have a short shelf life. It cannot be issued today and then served and executed in several months' time. It really depends. The length and life of the warrant depends on the probable cause and the facts and the circumstances. But a warrant certainly could be good today, but may have expired by tomorrow. So, what's the process for issuing a search warrant? Well, firstly, the police officer gathers the evidence to provide probable cause. They then write the warrant application, which we'll see later actually once signed becomes the warrant itself usually. They need to include the affidavits and sworn statements of the officers or the witnesses or the informants. Then they typically provide it to the assistant prosecutor or the supervising police officer for review. And then they present the application to a neutral magistrate. The magistrate would review the application and may require revisions, may say they need more information. The magistrate really wants this application to be, this warrant to be appeal proof, so if there is insufficient information, they will request more. Once the application is signed, then it becomes a warrant. The magistrate that issues the warrant must be neutral and detached. It doesn't have to be a judge. In many areas it's the town justice or some other clerk. It can't be an investigator that's colluding with the police, and also they cannot be paid a commission for each warrant approved, so that would affect their neutrality. The magistrate must review the warrant. They can't simply rubber stamp it, although studies show that some states and some areas the review takes less than 2 minutes. It cannot be seen as a rubber stamp. The magistrate has to really look at the probable cause and assess the warrant carefully before approving it. A warrant is required to arrest a person in their own home. Also, a search warrant is required to search a home and other areas where there may be reasonable expectations of privacy. The warrant is not required if, well, of course, it's not required if the consent or waiver is provided by the person. It's not required in a situation where there's an arrest with probable cause in public. Would be crazy for the police to be able to see a crime and find a person have probable cause to arrest, but then be unable to arrest as they have to go back to the office and get to the station and get a search warrant. So arrest with probable cause in public does not require a search warrant. We'll see later it requires the Gerstein hearing to assess probable cause. Warrant is not required to seize objects in plain view. We'll see there's a plain view exception later as well. Essentially there's no search for that object is found in plain view. The warrant is not required to search the home in an emergency. There's an exception in situations like hot pursuit of a fleeing felon and so on. Other emergency situations also allow for a search of a person's home. Then there are situations where both a search warrant and an arrest warrant are required. For example, the arrest of a person requires an arrest warrant. If that person is in another person's home, then in order to gain access to that home, in order to carry out the arrest, a search warrant is required. So in that situation, the police need to get a search warrant to enter the premises and an arrest warrant to enter the person that is in there. So there are some exigency exceptions certain exceptions for a warrantless search of a home. One of them is a hot pursuit of a fleeing felon. Second one is the imminent destruction of evidence or the need to prevent the escape of the suspect. A third area, clearly, if there's a risk of danger to the police or other persons, either inside or outside the dwelling. There's no need for the police to wait for an injury to take place. If they see a fight occurring inside a person's home, they can go in and break up the fight. So also the police with probable cause can enter a person's home, but this does not apply to minor offences. The question was whether there was a murder scene exception. If there's a murder scene, is a search warrant required in order to enter the scene of a murder? And the answer is yes. There is no exception for certain crimes like murder scenes. It must be an emergency situation in order for the warrantless intrusion into the home to be allowed and not be viewed as a Fourth Amendment violation. If a person is arrested without a warrant, then they must be brought before the magistrate without unreasonable delay for a prompt judicial determination of the probable cause. So if a person is arrested, then they have to be put before the judge or magistrate to determine if there was sufficient probable cause to justify the arrest without a warrant. And the courts consider that it was presumptively unreasonable if this hearing, known as the Gerstein hearing, does not take place within 2 days, 48 hours of the warrantless arrest. And the problem here, though, is that the remedy, if there is no Gerstein hearing and probable cause is not assessed and determined and validated within this period of time, there's no remedy known as to what the defendant can claim in that situation. So, search warrants. They are required where there's a reasonable expectation of privacy, so where a search, Fourth Amendment search, is taking place. Obviously that would apply to the home. Also locked luggage, maybe that's locked inside a car, luggage that's found inside a car that is locked. There's a reasonable expectation of privacy, so a search warrant is required by the police before they are able to open up that luggage. Search warrant is not required where there is no reasonable expectation of privacy. Of course, where the individual consents to the search. In plain view, we'll look at that, where the police have the right to be there and they find evidence in plain view. And also there's the exigency, the emergency exception, fleeing felon, report of fire in the home, and so on. As well as the exigent circumstances, the home can be searched with a warrant, with consent. And at the time of arrest, as we'll see under the Schimmel case, the police, when arresting an individual in their home, presumably with an arrest warrant, can conduct a search of the immediate area, the arm span area, in order to prevent the individual from lunging to get a weapon that may be dangerous to the police. So they can search, there's a limited scope search allowed incident to arrest. When police approach a home to search with a warrant, they are required to knock and announce. So unless there's reasonable suspicion of danger or of flushing of evidence and destruction of evidence, they must knock the door. Even if the door's open, they wait roughly 20 seconds before then barging in. The failure to knock and announce in certain courts, like federal court, is not grounds for exclusion of evidence. So the search also must be reasonable. So a search warrant conducted on a home, in certain statutes restrict the hours of daytime and certain restrictions that make the search reasonable. They can't just barge into someone's home in the middle of the night. It has to be reasonable, and statutes in different jurisdictions describe how reasonable searches are conducted. Can the police freeze a situation while they're waiting for a search warrant? And the answer to this is yes, if the freezing is reasonable. So, for example, the police go to someone's home. They're told that he has drugs in his trailer. He refuses to give them access to the trailer. Well, so they have to go. They refuses to consent. So the police have to get a warrant to search the trailer. So essentially what they can do is have this situation, they had a police officer accompany the man into the trailer, didn't allow him to leave for 2 hours while the warrant was issued. And this was considered reasonable. It was an emergency situation. It was tailored to the situation. And there was a realistic threat of the destruction of the marijuana evidence. So freezing the situation while waiting for the search warrant there was considered reasonable. Also, other situations where possibly holding passengers at the airport for a dog sniff of luggage for several minutes is not considered unreasonable. The response here has to be tailored, and if it's tailored to the situation and not overly oppressive on the individual, then the courts will often consider this freezing of the situation to be reasonable and not a violation of the individual's Fourth Amendment rights. So, what does a search warrant allow the police to search? Well, size matters here. If the police were searching for a stolen ring, and it's stated in the search warrant that that was what the warrant was issued for, then they can they can open drawers, jewelry boxes, anywhere that a ring could be found. However, if they're looking for a stolen TV, then they couldn't open those small drawers and boxes because it wouldn't be reasonable to find a TV in there. So size matters, and the actual warrant itself and the items that are identified in the warrant will set the scope of what the police are allowed to do when searching. Now, when the police find what they're searching for, they must stop searching. So when the warrant has been executed, the items listed in the warrant have been found, then the police have to stop searching. The scope of the search can change when the police are in the process of searching, if they have probable cause. So if the police are searching for a whole human body, they are allowed to look in areas where the whole body could fit. They wouldn't be allowed to look in small drawers and so on. If, for example, then they find a body part, they could then have cause to believe the body has been chopped into pieces, and then they are allowed to look into drawers and areas that those pieces could be found. So the scope can change during the search. Criminal procedure and the constitutional rights of US citizens.